Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 3 of Everything Compliance, the roundtable podcast that looks at everything in compliance. The members of the Everything Compliance Roundtable include Mr. Translations himself, Jay Rosen, Vice President at United Language Group, Mike Volkov, founder of the Volkov Law Group, Matt Kelly, founder and CEO of Radical Compliance, and Jonathan Armstrong, a partner in Coterie Compliance in London. In today's episode, we take a look at several topics. Mike Volkov discusses the internationalization of anti-corruption compliance enforcement. Matt Kelly leads a deep dive into the Agricultural Bank of China enforcement sanction action and explain what it all means for compliance officers going forward. Jonathan Armstrong leads a discussion on the new French anti-corruption law, Sapin II. And Jay Rosen takes a look at corruption through the lens of Paul Krugman's New York Times article on the invidiousness of corruption, focusing on the corrupt nature of compliance and undue influence. We go back to our weekly rants, and this week we have rants including and on the new UK surveillance law, the SEC domestic corruption enforcement action involving United Airlines, and the Chicken Littles of the compliance world claiming the sky is falling. This is Tom Fox. I'd like to thank you very much for listening to episode 3 of Everything Compliance. Hello, everyone. This is Tom Fox back with another episode of Everything Compliance. As you recall, the Everything Compliance panelists include Michael Volkov, Matt Kelly, Jonathan Armstrong, and Jay Rosen. Gentlemen, welcome.
Hi there. Good morning, good afternoon, good evening.
So once again, from all the way from San Diego, California to London, we have 4 of the top compliance practitioners to discuss some issues. And today we're going to start off with Mike Volkov. And Mike, at the recent ACI National FCPA Conference, Kara Brockmeyer and Dan Kahn talked about the increasing enforcement effort against corruption. And when I had heard the DOJ talk about that before, I'd simply focused on cooperation between prosecutors. But Kara and Dan both talked about a conference that the SEC and DOJ put on jointly. This was the 3rd conference where they were training prosecutors from outside the United States, and they both commented that this had gone far beyond the basics of anti-corruption prosecution, but really they have developed a worldwide, not team, but a set of prosecutors who can prosecute cases. And that really led me to think that with the Embraer case, with the VimpelCom case, we've now had tangible examples of prosecutors bringing anti-corruption cases outside the United States, and really the internationalization of enforcement. Are you seeing the same thing along these lines?
Absolutely, and I think the trend has been going that way. And even back up for a second, Tom, for years, the World Bank, for example, has been sponsoring a yearly conference at which prosecutors from all over the world come and meet for a week. And again, the focus is on establishing relationships and then how do you prosecute corruption type cases. So the fact that the SEC and DOJ have run a similar program obviously serves their interest in many ways. And there is this issue of internationalization of anti-corruption enforcement. I mean, let's take another step back, and not too many steps back, but for years we used to hear criticism from probably the chamber, some businesses, and you'd hear mutterings about how people would settle, let's say, with the Department of Justice and maybe bring along, the UK, the SFO, for example, in terms of a settlement type of agreement, but then they'd have to go out and settle with all these other countries independently and prosecutors in other countries. And there was a lot of criticism that it was like the same set of acts, but they were having to pay several different countries. Now, a lot of that changed when more and more countries passed their own anti-corruption laws to try to get, a piece of the pie, as they say, to try to get into this. What we're seeing now is the fruits of a lot of hard work in the international context. And DOJ, you'll see the FCPA prosecutors take off, to attend conferences, international conferences with regard to this OECD type things. And they have been pushing this for a long time because they're not only trying to get the cooperation through the multilateral, law enforcement treaties that are well known around the world, but they're now trying to extend that to sort of cooperation among the prosecutors, which you need. It's not just law enforcement; you need prosecutors to cooperate. So in response to that, what we're seeing, I think, first off, there was the SBM offshore case, right, which occurred where they deferred completely to the Denmark. I think it was the Denmark prosecutors in that case,
correct,
or the Netherlands. But yeah, and then we're also seeing because a lot of companies are, for tax reasons, are setting up their, quote unquote headquarters in the Netherlands. We've seen more and more sort of efforts with regard to the Netherlands as well, and we saw that in VimpelCom, where they are aggressively seeking even more of a penalty against other companies, the parent company as well, besides VimpelCom. So we're definitely seeing that Brazil and the United States have always had a good relationship on a law enforcement basis. They have a very effective MLAT treaty. Same with countries like Colombia and things like that. So the fact that we're working closely, for example, in the Petrobras investigation with them is not surprising at all. What I think is the real interesting issue that's coming up is China, because right now the United States has been started for the last 2 to 3 years an information sharing program with the Chinese, and obviously we helped them by arresting several of their some of the people who fled to the United States or fled to areas and trying to evade the Chinese judicial system with regard to corruption and corruption proceeds. So I think you see the internationalization going on. I think the China situation could be a game changer in the sense of, if you can imagine how many cases we've had in terms of the United States over the last 2 years, particularly the SEC has been just pummeling companies, and particularly in the medical device and pharma area in China. And as more and more of that information becomes shareable and more information becomes usable, we're going to see sort of, I think, some of the resistance to the Chinese judicial system, which is not known for fairness or, due process, but nonetheless is going to become a bigger issue. There are, and I don't mean to be a doomsayer on this, there is a limit, however, as to how far internationalization can go, in my view, because, we have each sovereign government has their own way of setting up whatever type of prosecution system they want to set up. And I don't think that it's fair to start to say that people have to adopt each other's system, whatever it may be. We criminalize certain things that people don't criminalize in other countries. Other countries may have administrative fines and whatnot. But I do think the other area that this will have a big impact in is going to be in sharing information and data privacy issues that come up in international enforcement matters all the time. In other words, a lot of times people have to go over to China to look at documents, and they're not allowed to bring the documents back. They're not allowed to, and you have to be careful to make sure that people in the United States don't have quote unquote control over the documents, even when they're viewing them over, let's say, a webcast or something like that. So there are real data privacy issues that I think the more that law enforcement cooperates and the more that prosecutors cooperate, I think you'll see sort of political pushes to ease some of the restrictions, at least as they apply to investigations and things like that. But I think it's no wonder, and it's no wonder that Kara and Dan touted this, and they should, because I think they've worked really hard on it, even though people don't really see it. But for example, Amber Herrera was very well coordinated with a lot of police, a lot of investigators on both sides and prosecutors on both sides. And what's interesting to me in Amber Herrera is you also have the criminal prosecutions of the individuals are not occurring in the United States. They're occurring in Saudi Arabia. They're occurring in Brazil, that emanate from the Amber Herrera case. So that sends, is that, satisfy the Yates memo? I don't know, in a sense, there's individual culpability there for 8 or 9 people in Brazil. So, we've also seen, obviously in VimpelCom, we saw how the Netherlands, shared in this. And I think what's going to happen is the U.S. government has been very deferential, I think, or the U.S. Justice Department, to other countries who have skin in the game. In other words, people who put time and effort into this, it's not like the department is going to say, I want the whole settlement. They're willing to, carve these up a little bit. And I think companies in the end are going to do better on the whole to resolve as many countries as they can at once, and probably end up paying less. And you won't have as many sort of follow-on prosecutions as you would in the international context. And I think that's all a good thing. It's good for the system, I think. But it can't lead to the concern that I have is we can't standardize exactly however countries want to, prosecute these cases. Some countries don't want to make it a criminal prosecution. That's up to them, but they can still extract fines or civil penalties or whatever. So that's I don't want it to be seen in this new Trump era as a way to ram things down other countries' throats in terms of how this is going to be handled. I think it's going to be a more sort of collaborative process, and I think you made a really good point, Tom, in your article about how this makes it harder and harder for anybody to sort of change the direction of this program, particularly at the United States level. There's so much resources and investment in it, and it also is so lucrative for the U.S. government. That's one of the reasons that I could never see, like the new Attorney General, assuming he gets confirmed, sitting there and saying, oh, well, let's just, take this system apart because the Chamber of Commerce wants us to do that. It's not going to happen. There's too many forces against it, and it's too important and lucrative to the United States Department of Justice. I mean, they make too much money from this. So I don't see it's interesting how all of these sort of trends in the internationalization, in a sense, the Justice Department and the career people have put in place a system that nobody can tinker with, except at the edges. Whether you're going to give 100% credit or whether you're going to decline prosecution, for somebody who cooperates and remediates. That's fine. We can argue about those things, but the basic premise of this program, I think, is just going to keep tooling along. So those are my thoughts on that issue.
Anybody have any questions?
Can I chip in, Mike? Mike, I think there are some really, really interesting points. My concern from an international perspective is, obviously we have had one case in the UK where the court seemed to say, no, the divvy up between the US and the UK authorities wasn't fair and the UK took too much. But at the same time, I think there's an interesting trend starting to emerge of when the US teams up with prosecutors in another country, that can distort the other country's system. both in terms of damages, which tend to be higher. The amount that's paid in the US tends to be higher for bribery in other countries. And in terms of sometimes people, and I've heard this talk about a couple of the specific examples that you discussed, people almost pleading guilty to offences that they don't really think are made out in local law, and the effect this could then have, because it's set a precedent in a foreign jurisdiction, that because corporations are thinking, well, I can get a global deal and it might not be prosecutable in my home jurisdiction, but let's just have some finality and not raise any arguments that we might have available to us as a defence. So I agree with you that there's a definite trend of cooperation. If I look at it from a UK lens as well, I see that all of the recent SFO cases, I think all of them, have almost a thank you note at the end of the SFO's announcement to say, mentioned in dispatches of the following countries who've cooperated. I don't think there's any in the last 18 months or so that hasn't had that international thank you note. But so I think internationalism is definitely a thing. But my worry, and I don't know the answers, is do these sort of settlements somehow undermine what's being done at a local level, particularly when the perception is that the US takes too big a slice of the cake? Question mark in Siemens, was the distribution fair, for example, between the German and the US authorities?
Well, that's what's interesting is think of the pattern here, because when FCPA enforcement was ramped up in the United States, there were a lot of concerns about people agreeing to sort of jurisdictional elements or other things that they don't think they could actually prove if they went to trial, or whether or not they were actually a violation of the FCPA. There were people who, contended that. I don't think that's true, but I do think there were, stretches of jurisdictional elements where people would say, boy, I don't see any case law that supports that. But people were agreeing to it. And I think on the same way as the international sort of system matures, you're going to see the same concerns coming out of constituent countries that have signed on to it, because it's going to mean pushing the law or stretching the law a little bit on some of these settlements. They're not going to always be in the core capabilities or the core sort of law areas for certain jurisdictions, particularly as you reach out to, some of the less involved countries that may be cooperating simply because bank transactions went through their banking system, and they facilitated, getting, rather than going through the whole elaborate international, letters of rogatory process, they, they short-circuited that with contacts at the Uruguay prosecutor's office. So I think you raise a really good concern. And, it takes a bunch of stubborn Brits, like some of your judges, to say, hey, you know what? This is going a little too far, and we're not going to sign on to this. And, that's one of the costs, I think, of having judicial involvement in the approval of these things, which I think is actually a good thing for the system, as opposed to, we do need people to watch out over your respective sovereign's laws. And so I don't have a problem with that. If anything, that means to me that as justice builds the system, that they've got to take sort of some regard for, due proper regard for the local laws and the impact that it's going to have. What I don't want to see, like I said before, is I don't want to see the Justice Department ramming down their view to everybody and saying, you've got to follow this. I mean, that's just not fair. It's not the right way to do it. But I think they're sensitive to that. I think they may have to get some pushback. And I think people like the Brits or, the French for sure are stubborn. And I don't, and I think for example, I think out of the Alstom case, there are a lot of bad feelings between the French and the Americans. What a surprise. In terms of how that case was resolved and the promises that the French made with regard to how they were going to locally prosecute it, and turned out to do very little. So, it goes both ways in terms of being too aggressive and trying to get people to do things, or being disappointed by people. And I think that's just the nature of the beast, because, frankly, if I were the Brits or the French, I wouldn't want people telling me how to prosecute, enforce my laws. That's up to me. It's bad enough if you sign on to a treaty, that's a different thing. Then you're saying I'm part of a community, the OECD and whatever. I'm part of that community, and I've signed on to it, and I've said I've agreed to this, and I will implement laws like this. But there's still discretionary issues that you need your judges, your people, to prosecute in the way that's best for your country's interests. And, with your all Brexit and everything's about the Brits, everything's about the Americans these days. Everybody wants to protect themselves first. So I think we may see a little pushback in that, but I don't see that trend, really changing much as we go down the road here.
So let me change focus just a little bit, Matt, because you wrote about a very interesting enforcement action with Agricultural Bank of China, and an enforcement action brought by the Department of Financial Services in the state of New York. And although this was a regulated industry, it got me wondering, under a Trump administration, could we potentially see other regulators start to bring more enforcement actions around compliance? I thought about that in the context of the Federal Reserve Bank's portion of the J.P. Morgan Sons and Daughters settlement. So I was wondering if you might be able to take us through the Agricultural Bank of China enforcement action and what you may see it portends for compliance going forward.
Sure. And this was one of the more interesting enforcement actions I've seen for a while. This happened in early November, and it was Agricultural Bank of China, which has only one branch in the United States in New York City. But it is a large bank globally. It is one of the largest in China. It's got $2.7 trillion in assets. So that puts Ag Bank right up there with Citibank, Bank of America. This is a large institution that the state of New York decided to take on. The facts of the case are that Ag Bank had terrible corporate compliance. I'll get to that in a moment. And sidelined its chief compliance officer in the United States to the point that she actually resigned in early 2014. And shortly thereafter, most of her compliance staff left as well. So that is a bad sign that your organization does not take compliance very seriously. What really happened was Ag Bank opened for business in New York in 2012. It was doing some dollar clearing transactions in New York for global customers. Almost immediately, the bank examiners in New York started finding problems with transaction monitoring and transaction details. They warned Ag Bank of China, clean this up. Not only did Ag Bank not clean this up, but its dollar clearing business was increasing, creating a bigger backload of questionable transactions. And at the same time, the bank was not taking any steps to rectify its deficiencies. Enter the, juicy stuff about the compliance officer. She immediately saw these problems when she arrived in, I believe, 2013. She brought them to the bank's attention, the U.S. management, who basically said, we don't really want you to look at this, but we can't stop you, so I guess you have to go ahead, but don't expect us to cooperate. A whole lot of that attitude. She had consulted with the Federal Reserve of New York, so suddenly the feds were also aware of this. And by 2014, this situation had deteriorated so much that she left, her staff left, and then finally we saw that Ag Bank was fined in 2016, just about, 5 weeks ago, for $215 million. Even for a large bank, $215 million is enough of a pain that this is going to be unpleasant. What I found most interesting about this settlement was more how the state agency in New York, the Department of Financial Services, DFS, how is DFS actually going to try to enforce the settlement that it reached with the Ag Bank? Some of the settlement terms include that Ag banks are going to have to hire an independent monitor who will be chosen by DFS. A new chief compliance officer must be brought in with, quote, full autonomy and independence, and then also annual risk-based internal audit plans approved by the board of directors, and various other items, a lot of written plans that are going to have to be implemented. So this is the sort of thing that I know compliance officers at first would say, yeah, this sounds great. This is what I need. I'm going to staple this settlement to my CFO and general counsel's forehead. I'm unclear how the state of New York is actually going to enforce this against a large overseas bank. In theory, this board of directors over in Beijing, perhaps they will care much more about compliance and risk-based audit plans. But what's that going to look like? Who does this chief compliance officer report to? There's a lot of governance questions here that I don't see how the mechanics of this are actually going to filter out. So it was a case worth watching, especially if you are a compliance officer in financial services, and above all, if you're in financial services in New York, because it does show this state agency, they're here to play. And I think that we're going to see a more muscular state agency there in New York, regardless of what the Trump administration might do. And I do wonder if there's going to be some sort of federal state tensions here. The state DFS is probably a great political stepping stone for those New York politicians who might have higher ambitions. I know we will all be shocked to hear that state enforcement people have political ambitions and might put it to good use. But it could happen. And lastly, for foreign banks with a branch in New York, and there's a lot of foreign banks who have one branch in New York, and that's all because they have to be in the U.S. when they don't even really like it, but you can't avoid it. This is going to be a big wake-up call for them that you're going to have to pay attention to compliance like U.S. banks because the state is going to force you to do it. So I thought it was fascinating. Tom, to your point about does this mean state agencies might try to step up attention to compliance in a Trump administration where the feds might soft pedal or backpedal this? I think it depends on who you are. Certainly, we'll see states, continuing to do their usual things, but it really depends on what the state law allows a state level regulator to do. State of New York gives a lot of power to its banking and financial services regulator now. That office was consolidated and created in 2011. It's got a lot of power. Not all states do. It is worth noting that a lot of states the legislatures are in Republican hands. So I don't necessarily see that there's going to be a big push for more regulation or enforcement at the state level, except states with big banking industries, that would be New York, California, Massachusetts, and North Carolina. They're all going to be in Democratic governor hands as of next year. Most of them are, except now for North Carolina, but that's about to turn Democratic. And then you would see, presumably, more regulators at the state who have some ambitions for stronger regulation. My other big question here, however, is aside from what state regulators might do to enforce, would we see state attorneys general in Democratic states try to sue the Trump administration on various grounds at various times to block federal enforcement plans, much like we saw Republican states suing the Obama administration? Are we going to see this flipped around? I don't necessarily know how that might work, especially if Democrats are going to try to block Republicans rolling things back. Don't forget that Republican states sued the Obama administration for rolling things forward. So there's a whole lot of mess here, but the Ag Bank settlement in New York, especially if you're in compliance and financial services, you really want to give that a read and just wonder, how's this going to work in practice, and are we going to see it more often? Because I think it's kind of a big deal for that industry.
So that's really interesting, Matt, on your thoughts about state Democratic administrations bringing suit against potential actions from a Trump administration. Certainly in the great state of Texas, where our attorney general was quoted as saying, I wake up, I sue the federal government, I go home and go to bed. We have a well-worn history of that, but suing to stop a rollback would be taking it to perhaps a different level than we've seen in the past. Really, any thoughts on how that might get affected or accomplished?
It's hard to say. And I don't know what the legal grounds necessarily would be, especially because, first, we don't know what the Trump administration may or may not roll back. But you can see some speeches, say, from Jerry Brown in California. You know, Jerry Brown, very early after the Trump campaign won, came out and said, you know, we're a democratic state with democratic values, and we're going to stick with those. And then I think you would probably see Andrew Cuomo and Governor of New York would also say that, that New York has very clear ideas about what it wants to do. They're going to wait and see, but I think around environmental protection, I think maybe around consumer product safety, you might see some resistance from Democratic states there. By the way, I should correct myself. I did say Massachusetts was a Democratic state. Technically, we do have a Republican governor, although that's really, I think, almost for show. He is a very, by Republican standards, does not support the Trump administration. But, we are very much in the blue state field. So I don't necessarily know how this is going to work. But there are already plenty of states that lean Democratic who are going to say, no, we don't want to go with what the feds might try to push nationwide. And I'm going to be very curious to see how that dynamic plays out.
Additionally, we've got some other regulatory bodies, maybe quasi-regulatory bodies, such as the Chicago Board of Trade, the New York Stock Exchange, or other bodies that would have some sort of jurisdiction over publicly traded companies. And perhaps they might actually do something if there was not action at the federal level, because I'm very intrigued. When you have a vacuum in enforcement, there's usually groups that move into that vacuum. And if there's a vacuum at the federal level, state groups will move into that. And if there's a vacuum at the state level, the federal groups will move in. So I think regulators from other areas we may not have seen as active could well step up. And I think this Agricultural Bank of China case really might be a forerunner of some things to come.
I would very much say that, that's possible, but any compliance officers who might be doom and gloom that, we're going to be unemployed because everything's going to get rolled back, get over it. This is going to be a key issue for compliance officers for quite a while. Compliance is not going away, that's for sure.
So, Jonathan, if I could turn to you, if I will look across the pond and ask you to even look across that lovely body of water, the English Channel, because Cordery recently wrote about a new French anti-bribery law called Sapin II. And certainly, as Mike Volkov indicated in some of his remarks, there's been a difference in prosecution philosophy between the United States and France around corruption issues. Part of that may have been because there was a difference in anti-corruption laws, but does the French law begin to address those, or what do you see from your perspective?
Yeah, I think this echoes some of what Mike said about internationalization and what Matt just said about compliance isn't going away. And I think obviously France has had anti-corruption law for many years. Even one of the presidential candidates could personally attest to that. But it's probably not been enforced as much as one would expect on a global stage. And I think in addition, some in France have been concerned about almost the cash drain, the significant amounts that have been paid to the US authorities for bribery from French corporations. If you look at the top 10, for example, FCPA actions, then France has 3 places in the top 10, Alstom with $772 million fine, Total with $398 million, and Technip with $338. And so obviously, when combined, that's a big number. Some, of course, in France are just not are driven not only by the amount of cash that's going out of the jurisdiction, but also think that clamping down on bribery is a good thing to do. And so this new law, Sapin II or Sapin II in French, is seeking to address some of that. And I think we'll also have some really interesting ramifications for compliance globally, one of which is that Sapin II gives extra support to whistleblowers. And traditionally, of course, there's been a real area of conflict for US multinationals, particularly in things like Sarbanes-Oxley whistleblower helplines, where the French authorities, the French data privacy authorities, have taken action against some US multinationals for running whistleblower lines into France. In some respects, the international compliance officer's job will get easier, I think, post Sapin II, because, of course, those systems in part will be required by local French law, and as a result, provided that the helpline is presented the right way, I think some of those obstructions will be easier to jump over. But the new law was adopted on the 8th of November 2016. There are still some small things to do before it formally passes into law. We expect it will apply probably from the late spring of 2017. And as well as increasing the powers of the prosecutors, it has some, if you like, proactive elements to it for those organizations that employ more than 500 employees or and have a turnover of more than 100 million euros. And again, I think this is a trend that we've been seeing globally, if you like, with almost the reversal of the burden of proof with some compliance legislation. And in some respects, although it's not a strict reversal of the burden of proof, this is similar to the UK Bribery Act, where obviously we have a failure to prevent offence, and Sapin II has these mandatory compliance programme requirements. Another aspect, I think, that's influenced by the UK, who in turn were influenced by the US, is the possibility of entering into deferred prosecution agreements. So we're likely to see that become a possibility, and that, of course, opens up the possibility of doing deals on a global basis for organizations like Total, and the possibility of getting a once and for all settlement when they discover wrongdoing. And additionally, we're going to have a new equivalent of our Serious Fraud Office, and sort of a bit like your DOJ, called the Agence Française Anti-Corruption, the AFA, which will have extra resources to get involved on the international stage, and will be led by a judge who's had experience of bringing anti-corruption cases in the past. The one caveat I would say about whistleblower protection, where I foresee difficulties further down the line, is that whistleblowers under the French legislation seem to get protection if they're good faith whistleblowers with no financial benefit. Now, how this will play out with a whistleblower who's potentially incentivized, for example, by the Dodd-Frank provisions, and they're on a bounty, remains to be seen. I see that whilst we've resolved some of the cultural differences between the US and France in the treatment of whistleblowers, obviously the monetization of a whistleblower claim seems to be a step too far for the French at this stage, so that there may be some conflicts ahead there. But on balance, I think that most of the provisions of Sapin II would be recognizable to a US or UK listener, and it seems to signal an intent from the French to get with the program. And I was over in Paris a few weeks ago all of the soundings we took locally are that this law will be enforced. It isn't just a sort of dead statute. And the main reason for that, again, I suspect, is the amount of hurt to the Treasury in some respects, rather than a motivation for other reasons. These are big numbers, big fines to big French financial institutions, and those that I was speaking to say that that's the real signal for France to play its part.
So, Jonathan, in terms of what a compliance practitioner or indeed a corporation might need to do you see any additional steps that a corporate compliance officer or a corporate compliance program need to initiate? But if they generally have a program which follows the strictures of the UK Bribery Act, the United States FCPA, the Brazilian Clean Companies Act, they're probably going to be okay. What should be the corporate compliance practitioner's response that Cordery might advise clients on?
I think from our point of view, I think if you've got a good program that's going to work, under that legislation that you've mentioned, and particularly things like the principles of good compliance, let's call them that, under the UK Bribery Act, then I think that your work in terms of adapting that for your French operations isn't going to be significant. Translation, of course, I'm sure Jay could speak to, is probably a wise idea. If a regulator is going to ask to see your processes, even if you've got a relatively small head count, it's probably a good idea to let that regulator see your materials in French rather than English. And I think we will get some nuances as we head towards this implementation phase. As I say, there are still a few legislative boxes to be checked/ticked, and then we might improve. But my expectation is that a good global compliance program will get you in the high 80s, the low 90s in terms of percentage compliance. So I think that will be a great framework. Of course, there are some complexities for some organizations in terms of things like joint venture operations, as ever, where that will be challenging. And I think what we can also expect as well is that those organizations that trade heavily with large French corporations can expect the usual set of questionnaires to be delivered as they try and channel these measures through the supply chain as well.
Mike or Matt, do you guys have any questions or comments of Jonathan?
I will trust Jonathan's expertise here on Sapin II, and when I've looked at it, I have my general take has been that it's not going to be a terribly onerous event for those people already compliant with the FCPA. But as with all things France, the proof will be in the enforcement, and I look forward to seeing what that might look like sometime.
Yeah, I think that's right. That's where, the proof will be in the creme brulee.
With that, and certainly an excellent segue into speaking with Mr. Translations himself, Jay Rosen. Jay, you have talked about the need to translate into local languages, obviously for content and for business process. But Jonathan brings up a great point, which is, what do you do when the regulators come knocking? And so how does translation of your best practices compliance program into a local language, how would you see that in the Tom Fox document mantra?
I would, just see that as another step towards a company's commitment to, having its documentation available for all employees to read. So when you say document, but if the only document is an English code of conduct and policies and procedures, that's not going to get you very far. So especially with how particular we all know the French are, I think it would really behoove them to have these documents in French so they can present to the local regulators if they ever come a knocking.
Well, Jay, you had a couple of interesting posts recently where you put up actually an editorial of Paul Krugman in the New York Times where he talked about corruption, not in terms of specific dollars, bags of cash, but really influence and incentives. Now, he was speaking about it in the context of President-elect Trump and his administrations, but I was really intrigued by that approach, particularly when you consider the J.P. Morgan enforcement action and even the prior Qualcomm and Bank of New York Mellon enforcement actions in hiring as really ways to influence foreign officials and the nefarious nature of that. So what did you see from Krugman and how might we draw lessons from that?
Yeah, so Krugman basically, ever since President-elect Trump won the election, many parties have been calling for him and his family business partners to remove themselves from day-to-day operations and set up the Trump Organization of a Blind Trust. And, this is probably a difficult thing to do considering the Trump empire concerns real estate, and it's very hard to determine the value of these assets. In his opinion piece, Krugman looked at the potential for corruption within the Trump administration, as you said, and he says it's really not about the money, but it's about the incentives that present the problem. And Krugman argues that a president's policies usually reflect a combination of practicality, what will work best, ideology, what fits that person's preconceptions. But now we've got a third factor to consider. What policies can officials undertake that will really personally allow them to monetize these actions? So one interesting thing that we just saw last week in Indiana is that Carrier Air Conditioning, which is a subsidiary of defense giant United Technologies, was strongly convinced by the president-elect not to close a factory in Indiana, coincidentally home state of the Vice President Pence. And I'm wondering if the billions of dollars that the federal government spends with United Technology had anything to do with this reversal. So Krugman touches on next in this article about for-profit education and Betsy DeVos's nomination as Secretary of Education. Sounds a lot like, can anybody say Trump University? And Trump's actual infrastructure plans. So next he hypothesizes about the potential impact of corruption on foreign policy. And I think this is the meat of where we wanted to go, that countries like Britain or Canada would not be able to curry favor with the incoming administration to waive regulations to, say, build a new Trump golf course in Toronto. But someone like our good friend Russia's Vladimir Putin might be able to funnel vast sums of money to the man in exchange for potential withdrawal of security guarantees for the Baltic states. So one would like to hope that national security officials are explaining to Mr. Trump just how destructive it would be to let business considerations drive his foreign policy. But reports say that Trump has barely met with those officials, refusing to get the briefings that are normal for a president-elect. But one good thing that we know is that real Donald Trump is still staying up at least until 11:40 p.m. on Saturday night and critiquing Alec Baldwin's Trump impersonation on SNL. So,
well, Jay, let me just ask you, and probably Mike Volkov's the only person on this podcast old enough to remember this, but President Kennedy was very famously did something called jawboning, which he would go to the bully pulpit of the presidency to do things like suggest to the U.S. steel industry that if they didn't roll back a price increase, that the U.S. government might just go overseas to buy its steel. And that was effective. They did roll their prices back because the president objected in that manner. How is what Kennedy did really different than Trump, calling up Carrier and saying, I don't like this?
Well, hey, I wanted to jump in here just to show my age. Not only we have a little bit of history that goes even before Kennedy, where, as you recall, when there was the strike and Trump and Truman seized the manufacturing facilities.
It was coal mine.
So I think
seized the coal mine.
Yeah, exactly. So look, I think Kennedy, the question that comes up with Trump is also that apparently there was some ownership interest that he himself might have in owning stock of United Technologies. But I don't even know that he's aware of that or that motivated his actions. But I think a lot of this gets down to, appearance. Kennedy may have said, we're going to go, purchase our steel from overseas, but at the same time, I don't know that Kennedy had any investment in any particular business that was going to succeed as a result of that, or could possibly succeed or gain from that. What I think Krugman and what I think Jay articulated very well is there are some real sort of interconnections here that raise issues with regard to Trump and with regard to the appearance issues. I mean, we as lawyers, we try to address those issues, although the lines get blurred a lot these days, but in terms of conflicts of interest. But it seems to me like we have some real issues that have to be fleshed out with regard to Trump's tentacles. And the problem is we don't really know where all of his businesses extend into, and we've never gotten that sort of transparency. But it is a unique situation, that's for sure.
Tom, can I jump in here too?
Sure.
I think one critical distinction is that Kennedy and Truman were generally talking to a whole industry. Trump is clearly talking to specific companies. So that's one difference. And secondly, we do have to think about his, I guess, even if he doesn't consciously grasp this or not, and I'm guessing not, the intermingling of his personal business interest and state policy. The thing that jumped out at me over this weekend wasn't so much Carrier, which was a bad move on Trump's part, but his call to Taiwan when he has business interests in Taiwan. If I were Beijing, the first thing I would do would be to call up Taiwan, because they do have interests that intersect and they do communicate with each other, and say, we'll give you a break on these issues that are creating tension between us. You put the Trump Tower in Taiwan, you put that on the slow road, and we'll get back to you on when to put it on the fast road. Then China negotiates with the United States, and when we are in some tense point, Beijing calls Taiwan back up and says, now you have to call Washington and say, we think you should side with China. By the way, we're going to give your tower permissions here. And there are now multiple ways for China to advance its own interests, because it can attack the United States through two different points: through the public policy point, with Trump at the head of the federal government, plus Trump's personal business interests, which until now we've never had this before. Donald Trump is just going to set a tremendously terrible example for conflicts of interests and tone at the top, unless he makes changes that have to be made. And I don't buy it when he says there's real estate it's difficult for me to liquidate. If he's serious about running the United States government, all he has to do is cut the price. The faster he cuts it, the faster it gets sold. It's bogus when he says he can't do this, as it is so bogus with much of what he says. And it'll be interesting to see how all of this filters out. I think that there's going to be a lot of corporate governance concerns about, does Carrier have to disclose its conversations? If you are a competitor to UTC, do you have to disclose as a risk factor that maybe UTC will get better breaks from the federal government because it did a favor to Donald Trump in Indiana? We have no idea how this is supposed to work, and least of all, Donald Trump and his people.
So, Jay, I wanted to turn just a little bit, because you had another very interesting post about the remarks of Sally Yates at the ACI National FCPA conference, where she talked about individual accountability. And what about those remarks really struck you?
Thanks for bringing that one up, Tom. So, you were actually there, so I'm kind of getting my information secondhand by reading the press release of the remarks from the DOJ. But I got the feeling that Deputy AG's speech sounded a lot like a valedictory address, and she recalled her professional lifelong battle against corruption. And in the address, she detailed how her namesake memo brought up the concept of voluntary self-disclosure and how this has, in effect, become a 10th standalone Phillip factor. And, these are the factors on which you're going to judge a case's merits and figure out, what type of treatment and what type of penalty they may have to pay. And through recent enforcement actions, it's pretty clear that there's a difference in treatment between those companies who self-disclose versus those who don't. And so that was one big point she made. The other thing that she announced was there's a new resource available for the FCPA ethics and compliance community, which we'll have in our show notes. And it's www.justice.gov/individual-accountability. And she said this would be a great place for you to go if you have questions about, a transaction you're contemplating or some issue that you found. And she also said that it's actually just as easy and probably more efficient to pick up the phone and call your friendly local AUSA. But I doubt how many people will actually take her up on that offer. She closed with a prediction that in the coming months, we will see a high percentage of cases accompanied by criminal or civil actions against individuals, which is really the theme about the Yates memo. And here's the meat of what we're coming from, is that the quote was, individual accountability isn't a Democratic or Republican principle, but it's a core value of our criminal justice system that perseveres regardless of which party is in power. And I also touched upon this in my can read about the next prosecutor up. And I think we're going to, wrap up and get into our rants. And if I can take the first rant, I think there are too many folks out there that it's Chicken Little and the sky is falling. And either the five of us are involved in groupthink, or we all understand that the compliance on a global nature and on a local nature is becoming well embedded within the corporations, within the bar. And we don't really collectively see it going anywhere. So, I hope we haven't missed that one like we missed the election. But I think we all can feel safe that there are enough people pulling for this globally. And, the unknowns that Matt spoke about is, exactly what are those conflicts of interest and what kind of new issues are we going to see developing under the Trump administration, because we definitely are going into uncharted territory.
Well, Jay, thanks for leading off our rant section. Jonathan, why don't we just go in reverse order? Jonathan, what's either do you want to rant about, or being English, what's in the front of your mind?
Well, it's front of my mind. It's a semi-rant, I guess. You may not know, a slightly obscure piece of legislation came in the UK last week, which gives the Serious Fraud Office and others more detailed powers to intercept communications, and also requires communications providers, so that's telcos, ISPs, etc., to retain logs of who contacted whom for 12 months to allow the SFO and others to intercept that data. And this seems to me to be something we should very much look as a global trend as regulators march towards using big data for regulation. Obviously, that's an enormous pot of data. The SFO in their last accounts disclosed the fact that they're buying this new supercomputer to sweat big data. They already use autonomy, so a system that enables it to do that. And how do we know that they use autonomy? Because they had perhaps a very unusual disclosure that they had to disclose that they were investigating the autonomy acquisition using autonomy software to do the investigation. And it just seemed to me to be an interesting change to the rules. And we have seen in some recent investigations the fact that the prosecutors have said that they've been using mobile phone records, cell phone location data, et cetera, in the prosecution. And I think we can see more sweating of electronic data. We know that executives are particularly bad at not only doing bad things at times, but also recording them, particularly in emails late on a Friday night when they're, what we English say, tired and emotional. And so these emails are going to come back to haunt executives. The next 10 years is going to give us a lot of fun with these new records that the SFO will be able to obtain.
Matt Kelly, what's at the front of your mind, or what do you want to rant about?
So here's what caught my mind recently. On December 2nd, the SEC enforced an action against United Airlines. They fined them $2.4 million for books and records violations where United had altered its flight schedule to be more accommodating to the then head of the Port Authority of New York and New Jersey. Once that scandal came out that United was currying favor with the head of the Port Authority, he lost his job, and United eventually then returned its schedule to normal practice. But nonetheless, what's interesting here is that if New York and New Jersey had been a foreign country, this would have been a clear-cut case of FCPA violation. Really what they've done is taken the spirit of the FCPA's books and records violation and applied it domestically. And I've already seen one person say this is the first ever case of a Domestic Corrupt Practices Act enforcement. I'm very curious to see where this goes because we do not actually have a Domestic Corrupt Practices Act that the SEC could do this. On the other hand, very clearly, United investors were somehow wronged, not to a great extent, but they were, not to mention the poor minions who were flying in and out of New York and New Jersey. So I'm very curious to see, is the SEC trying to establish a new doctrine here? We're going to see this more often. Is somebody going to try and shoot this down? Will this all go away when the Trump administration comes in? Nobody knows, but it's an enforcement action that caught my eye.
It's a very interesting one, and I've been thinking about it as well. So I think, unfortunately, Mr. Volkov had to leave us. So that will conclude episode 3 of Everything Compliance. Gentlemen, as always, it's been a great pleasure and honor to be with you on this podcast, and I look forward to continuing the conversation. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of Everything Compliance. I have 2 requests of you. The first is if you have listened to this podcast on iTunes, if you would rate this podcast, I would greatly appreciate it. It would help our rankings. The second is we'd love to do a mailbag episode. So if you have any questions you'd like to email into the Everything Compliance gang, you can address them to the podcast or you can address them to the individual panelists. Shoot me an email at tfox@tfoxlaw.com. This is Tom Fox, and I would like to thank you for listening to episode 3 of Everything Compliance.